Oh, hello. Welcome to my bar review show. Today we're talking about corporations. Corporations involve setup, people, stocks, specials. We will also talk about LLCs. All right, setup. Setup involves formation, governance, termination, mergers and acquisitions. Formation involves pre-incorporation transactions and incorporation. Pre-incorporation transactions. Promoter liability. Pre-incorporation agreements. Promoter is personally liable for knowingly acting on corporation's behalf before incorporation. Remains liable after corporation comes into existence unless a novation occurs releasing the promoter, a third party looks only to the corporation for performance, or promoter had no actual knowledge corporation's charter had not yet been issued. Fiduciary duty. Promoter can be liable to corporation for violating fiduciary duties. Compensation. Promoter may seek compensation or reimbursement for related expenses, but cannot compel the corporation to pay because acts were not undertaken at corporation's direction. Corporation's liability. The general rule is the corporation is not liable for pre-incorporation transactions, even those for corporation's benefit, because no principal or agency relationship exists. Corporation is liable if it expressly or impliedly adopts contract by accepting transactions benefits or gives express acceptance of liability for debt. Incorporation. Incorporation articles. These must include the corporation's name and be filed with the state. They may enumerate the powers corporation possesses, limit corporation's duration, and include a statement of corporation's legal purpose. Corporation's existence begins when the articles are filed, unless articles establish a later date. Ultra vires actions beyond the scope of legal power or authority. Act. When corporation with stated narrow business purpose in its articles subsequently engages in activities outside the stated purpose, third party generally cannot escape liability for transaction that is ultra vires corporate act. Challenges to ultra vires acts under RMBCA will only be enjoined if challenge is equitable action against director, officer, or employee who engaged in action, or state can initiate the proceeding. De jure corporation. When all statutory regulations for incorporation are satisfied, corporation is liable for corporate activities. De facto means state of affairs true in fact, but not officially sanctioned. In contrast, de jure means state of affairs in accordance with the law, or officially sanctioned. Defective incorporation. Lack of good faith. Person who conducts business as corporation without complying with incorporation requirements is personally liable for non-existent corporation's obligations. Good faith effort. 2 ways to escape personal liability. De facto corporation. Owner must make good faith effort to comply with incorporation requirements and operate a corporation without knowing requirements were not met. Corporation by estoppel. Person dealing with entity in contractual agreement as if it were a corporation is estopped from denying its existence and seeking personal liability. Medium break. All right, now we're moving on to governance. Governance involves instruments and organizational meeting. Instruments. Incorporation articles. The board of directors can amend articles if no stock has been issued. If stock has been issued, then board of directors adopts amendments and submits amendments to shareholders for majority approval. Bylaws. Lawful provisions for management of corporation's business and regulation of corporation's affairs, not inconsistent with articles. Conflict between articles and bylaws. The articles control. Organizational meeting. These are for officers' appointments, bylaws adoptions, and contracts approval. All right, we're moving on to termination. It involves involuntary termination and voluntary termination. Voluntary termination. Procedure after issuing stock. Board of Directors adopts proposal for cease dissolution and shareholder majority approve. Winding up. Dissolving corporation can continue to exist. 2. 1. Collect assets. 2. Dispose of property not distributed to shareholders. 3. Discharge liabilities. And 4. Distribute property among shareholders according to their interests. Involuntary termination. Creditors can pursue involuntary dissolution only for an insolvent corporation. Creditors can pursue involuntary dissolution only for insolvent corporation. Shareholders can pursue involuntary dissolution if corporation's assets are being misapplied or wasted, directors are acting illegally, oppressively, fraudulently, if shareholders are unable to break the director's deadlock causing irreparable injury, or if shareholders are deadlocked and fail to elect a successor director. Shareholders can pursue involuntary dissolution if corporation's assets are being misapplied or wasted, directors are acting illegally, oppressively, or fraudulently, if shareholders are unable to break the director's deadlock causing irreparable injury, or if shareholders are deadlocked and fail to elect successor directors. Oppression doctrine. Shareholder oppression doctrine protects minority from oppressive majority control. Statutory provisions regarding involuntary dissolution are interpreted to protect shareholders' reasonable expectations. Shareholder oppression doctrine protects minority from oppressive majority control. Statutory provisions regarding involuntary dissolution are interpreted to protect shareholders' reasonable expectations. Finally, we're on mergers and acquisitions. They involve mergers, asset acquisitions, stock acquisitions, dissenting shareholders' appraisal right. Mergers require board of directors and shareholder approval by majority vote at meeting with a quorum, majority of shares entitled to vote, present for each corporation. Required docs must be filed with the state. Asset acquisition. Like merger approval, except only TransferOrs corporations, board of directors and shareholders are entitled to vote on the transaction. TransferOr Corp remains liable for its debts. Stock acquisition. Corporation 1 can acquire stock in another corporation, Corporation 2, to acquire control of Corporation 2 without doing merger by exchanging its own Corporation 1 stock for that Corporation 2 stock, or by paying cash or other property for stock. Dissenting shareholders' appraisal rights. The rule. A shareholder who objects to merger or acquisition, or whose rights are materially and adversely affected by amendment to corporation's articles, may be able to force corporation to buy his stock at fair value as determined by appraisal. Qualifying shareholders are any shareholder entitled to vote on merger, acquisition, or amendment of the corporation's articles. All right. Second part, we have people. People involve shareholders, board, and officers. Shareholders involve meeting requirements, voting requirements, records inspection, shareholder suits, and liability. Meeting requirements. Failure to hold meetings does not affect corporation's existence or invalidate corporation's business. Annual. Primary purpose is to elect directors. Special. Board of directors or shareholders who own at least 10% of voting shares may call. Notice. Voting shareholders must be notified of time, date, and place in a timely manner, which is no less than 10 days and no more than 60 days before the meeting. Shareholder may waive notice in either writing or by attending the actual meeting. Unanimous written consent. Shareholders can take any action that could have been taken at meeting by unanimous written consent. Shareholder resolutions. Submitted for shareholder action at shareholder meeting. Cannot bind corporation or board of directors unless amending bylaws. Can regulate political expenditures. Voting requirements. Eligibility. Generally, only record owners of voting stock are permitted to vote. Owner of voting stock at close of business on record date has right to vote. Corporation generally cannot vote its own stock. Quorum requirements. Majority of votes entitled to be cast on a matter. Cumulative voting for directors. Shareholders can cumulate votes to allow minority shareholders to elect representative to board of directors. Proxy voting must be in writing and delivered to corporation or corporation's agent. Voting with other shareholders. Voting pool. Binding voting agreement under which shareholders retain legal ownership. Does not need to be filed with corporation. There's no time limit. Voting trust. Trust to which legal ownership of shareholder stock is transferred. Trustee votes shares and distributes dividends in accordance with trust. Must be in writing, limited to 10 years, and filed with the corporation. Management agreement. Allows shareholders to alter the way corporation is managed, even if agreement is inconsistent with statutory provisions. Records inspection. Shareholder with a proper purpose, relates to shareholder interest, has the right to inspect and copy corporation records on a 5 days written notice. Shareholder suits. Direct actions. Action to enforce shareholder right for director or officer's fiduciary breach, or action based on grounds unrelated to shareholder status. Derivative actions. Shareholder sues on corporation's behalf for corporation's harm. Standing. Plaintiff must have been a shareholder at the time of the wrong and at the time action is filed. Must continue to be shareholder during the litigation and must fairly and adequately represent corporation's interests. Written demand on board of directors must be made unless it would be futile. Futility exception is not recognized under RMBCA. Rejection of demand is tested against the business judgment rule. Litigation expenses. Plaintiff can seek reimbursement from corporation for reasonable litigation expenses. Dismissal by the board. Only if qualified directors majority decide in good faith, after reasonable inquiry, action is not in corporation's best interests. Liability. Piercing the corporate veil. Totality of the circumstances. Look to whether corporation is being used as a facade for dominant shareholders' personal dealings. For instance, whether corporation is an alter ego or mere instrumentality of shareholder, and whether there is unity of interest and ownership between corporation and its members. Factors considered: undercapitalization, self-dealing with corporation, siphoning of corporation's funds, shareholders' domination over corporation, disregard of corporation formalities, using corporate assets as shareholders' own assets, using corporate form to avoid statutory requirements, fraudulent dealings with corporation creditor. Controlling shareholders' fiduciary duty to minority shareholders. Controlling shareholder is shareholder or shareholder group acting in concert who holds high enough ownership percentage in company to enact change at the highest level. Shareholder owning 50% plus one of corporation shares is automatically a controlling shareholder. Duty arises if controlling shareholder is selling interest to outsider, seeking to eliminate other shareholders from corporation, or receiving distribution denied to other shareholders. Duty to disclose. Info reasonable person would consider important in deciding how to vote on transaction, and fair dealing duty when purchasing minority shareholders' interests. All right, we're on to the board. Board involves meeting requirements, voting requirements, inspection rights, composition requirements, term, compensation, committees, and duties. Meeting requirements. Directors are entitled to 2 days' notice of date, time, and place of special meetings. Purpose is not required. Regular meetings may be held without notice of date, time, place, or purpose. Board of Directors can act by unanimous written consent without holding a meeting. Voting requirements. Assent of the majority of directors present is necessary for board approval, generally. To be valid act, quorum must have been present. Majority of all directors in office constitutes a quorum. Agreements between directors as to how to vote, pooling agreements, are generally unenforceable. Directors may not vote by proxy. All right, inspection rights. Director has right to inspect and copy corporation's books and records. Composition requirements. Can have as few as one. Director must be a natural person and not corporation. Directors are selected at annual shareholder meeting. Term. Typically, it's 1 year, but may serve longer if staggered terms. Directors can be removed by shareholders with or without cause unless articles provide otherwise. A director may resign at any time with written notice to Board of Directors, its chair, or corporation. Compensation. Permitted. Committees may generally exercise whatever powers are granted to them by board of directors, articles, or bylaws. All right, now we're going to talk about duties, which are kind of a long section. We'll talk about the care duty, the loyalty duty, and the indemnity or insurance. Again, we're still talking about the board's duties. Care duty. Prudent person. Director has duty to act with care. A person in a like position would reasonably believe appropriate under similar circumstances, the objective standard, and must use any additional knowledge and special skills he possesses when deciding how to act. Reliance protection. Director can only rely on officers, employees, outside experts, attorneys or accountants, or committees' info and opinions if director reasonably believes them reliable and competent. Business judgment rule. The rule. Rebuttable presumption. D reasonably believed his actions were in corporation's best interest. Does not apply when director engages in conflict of interest transaction with corporation. Business judgment rule is part of the care duty. To overcome the business judgment rule, it must be shown director did not act in good faith. Director was not informed to extent he reasonably believed was necessary. Director had material interest in challenged conduct and was not objective. Director failed to devote attention to corporation's affairs. Director failed to timely investigate material concern matter, or director received financial benefits to which he was not entitled. Good faith presumption is overcome in case of fraud, duty dereliction, condoning illegal conduct, or conflict of interest. All right, now we're talking about the loyalty duty. Requires director to act in a manner director reasonably believes is in corporation's best interest. We're talking to this dog. You won't understand this, but this thing called self-dealing exists that loyalty duty prohibits. Yeah, I know, disloyalty, crazy, right? But dogs are loyal. All right, we're going to talk about the rule, the transaction type, and safe harbors. These are all parts of the loyalty duty. Self-dealing. Director's conflicting interest transaction. Rule. Director who engages in conflict of interest transaction with his own corporation violates the loyalty duty unless transaction is protected under the safe harbor rules. Director cannot profit at corporation's expense. Transaction type. One that would normally require board of directors approval and is so financially significant to director it would reasonably be expected to influence director's transaction vote. Includes dealings with persons related to director. Safe harbors. Disclosure of all material facts, and board of directors or shareholders without conflicting interest majority approval. Transactions, substantive and procedural, fairness, to corporation at the commencement time. Corporate opportunity usurpation, interest or expectancy test. Does corporation have existing interest or expectancy arising from existing right and opportunity? Business line test is opportunity within corporation's current or prospective business line, and how expansive is corporation's business line. Other factors, third parties' relationship to D, and directors to corporations. Third parties' relationship to director and directors to corporation. How and when director acquired knowledge of opportunity. Competition with corporation. Director who engages in business venture that competes with corporation has breached their duty. Indemnity or insurance. Corporation required to indemnify director for any reasonable expense incurred in successful defense of proceeding against director. Corporation is prohibited from indemnifying director against liability due to receipts of improper personal benefit. Corporation may indemnify an unsuccessful defense if director acted in good faith with reasonable belief conduct was in corporation's best interest, and director did not have a reasonable cause to believe the conduct was unlawful. All right, now we're on to officers. Officers involve selection, authority, duties, liability, indemnification or insurance, removal, and other employees. Selection. Elected by board of directors. Authority. Actual. Defined by corporate bylaws or board of directors. Implied. To perform those tasks necessary to carry out officer's duty by virtue of her status or position, so long as matter is within ordinary business's scope, not extraordinary transactions. Apparent. If corporation holds officer out as having authority to bind corporation to third parties. Duties. Publicly traded corporations CEO and CFO are Sarbanes-Oxley Act subject and must certify corporation's financial reports' accuracy to the SEC. Care duty. Prudent person. Director has duty to act with care a person in a like position would reasonably believe appropriate under similar circumstances. This is the objective standard, and is required to use any additional knowledge and special skills he has when deciding how to act. Reliance protection. Director can only rely on officers, employees, outside experts, attorneys, accountants, or committees' info and opinions if the director reasonably believes them reliable and competent. Business judgment rule. The rule. Rebuttable presumption, director reasonably believed his actions were in corporation's best interest. Does not apply when director engages in conflict of interest transaction with corporation. Business judgment rule is part of care duty. To overcome the business judgment rule, it must be shown director did not act in good faith, director had material interest in challenged conduct and was not objective, director was not informed to extent director reasonably believed was necessary, director failed to devote attention to corporation's affairs, director failed to timely investigate material concern matter, or director received financial benefits to which he was not entitled. Business judgment rule, good faith presumption, is overcome in case of fraud, duty dereliction, condoning illegal conduct, or conflict of interest. Publicly traded corporation CEO and CFO are Sarbanes-Oxley Act subject and must certify corporation's financial reports' accuracy to SEC. All right, loyalty duty. Requires director to act in manner director reasonably believes is in corporation's best interest. Self-dealing, director's conflicting interest transaction. The rule, Director who engages in conflict of interest transaction with his own corporation violates the loyalty duty unless the transaction is protected under safe harbor rules. Director cannot profit at corporation's expense. Transaction type: one that normally requires board of directors approval and has such financial significance to director, one would reasonably expect it to influence director's vote on transaction. Also includes dealings with persons related to director. Safe harbors: all material facts disclosure and board of directors or shareholders without conflicting interest majority approval. Fairness, substantive and procedural of transaction to corporation at commencement time. Corporation opportunity usurpation. Interest or expectancy test. Does corporation have existing interest or expectancy arising from existing right and opportunity? Line of business test. Is opportunity within corporation's current prospective business line, and how expansive is corporation's business line? Other factors: third party's relationship to director and of director to corporation. How and when director acquired knowledge of opportunity. Competition with corporation. Director who engages in business venture that competes with corporation has breached their duty. Liability. Officer is liable to third party if officer has acted in officer's personal capacity or has engaged in purposeful tortious behavior. Officer is not liable for performance of officer's duties to corporation. Indemnification or insurance. Corporation is required to indemnify director for any reasonable expense incurred in proceeding against director's successful defense. Corporation is prohibited from indemnifying director against liability due to receipts of improper personal benefit. Corporation may indemnify Corporation may indemnify in unsuccessful defense if director acted in good faith with reasonable belief conduct was in corporation's best interest, and director did not have reasonable cause to believe conduct was unlawful. Removal. With or without cause at any time. Other employees. Employee can act on corporation's behalf to extent of employee's authority and is usually protected as agent from liability for action undertaken in accordance with that authority. All right, moving on. Part 3, stocks. Stocks involve types, issuance, distribution, and sale. Types. We have common versus preferred. Common. Basic ownership interest that entitles owner to vote on corporate governance matters. Preferred. Has preference over other stock with regard to distributions. Issuance. Authorization by board of directors and or shareholder. Consideration. If adequate, stock is deemed fully paid and non-assessable. Stock subscriptions. Pre-incorporation subscription is irrevocable for 6 months from subscription date unless all subscribers agree to the revocation. Stock rights, options, and warrants can be issued by the board of directors. Shareholders' preemptive rights. Shareholders' right to purchase newly issued shares so as to maintain shareholders' proportional ownership share as provided by articles. Waiver of preemptive rights in writing is irrevocable. Securities registration. Required for public stock offerings. Corporation must file registration statement with SEC and provide buyer with a prospectus. Distribution. Board of Directors is authorized to make distributions, usually in the form of a cash dividend payment. Limits. Corporation cannot distribute if corporation is insolvent or if distribution would make corporation insolvent. Director's liability for unlawful distributions in violation of care or loyalty duties. Director is personally liable to corporation for amount in excess of lawful amount. Shareholder suit to compel distribution. Shareholder can sue to enforce his individual right by proving existence of funds legally available to pay distribution and director's bad faith for refusing to pay distribution. All right, sale. Private restrictions on sale. Enforceability. 1. Security must be certified. 2. Restriction must be conspicuously noted on security certificate. And 3. Person must have knowledge of restriction. So you have certified, conspicuously noted, and knowledge. Stock transfer restriction challenges. Test is one of reasonableness. Federal causes of action. Rule 10b-5 action. Must meet each requirement. P. Purchased or sold security. Interstate commerce use. Director's fraudulent or deceptive conduct. Untrue statements of material facts. Failure to prevent misleading statements or insider trading. Materiality. Reasonable investor would find fact important to decide whether to purchase or sell a security. Scienter. Director must make statement intentionally or recklessly. P's justifiable reliance on director's fraudulent conduct. And finally, harm to purchaser. Rule 16b action. Elements. Publicly traded corporations must have securities traded on the National Securities Exchange or have assets of more than 10 million and more than 500 shareholders. Corporate insiders are directors, officers, shareholders with more than 10% stock. Short swing profits. Corporate insider both bought and sold corporation stock during any 6-month period. And then we have SEC report of stock ownership change. All right, part 4, specials. Close and closely held. Only few shareholders. Stock is not publicly traded. More relaxed governance style. Foreign. Incorporated in another state. Must register and seek certificate of authority from current state. Professional. Purpose is statutorily limited to rendering a professional service. S-corps. Corporation avoids double taxation by passing income and expenses through to its shareholders, who are then taxed directly. Benefit corporation. For profit. Corporate purpose is creating social or environmental benefit, not maximizing shareholder profit. All right. LLCs involve creation, management, dissolution, direct and derivative suits. Creation. Created by filing organizational articles with state, including LLC's name, mailing address, and if there are no members on filing statement to that effect. Does not come into existence until LLC has at least one member. Some states apply de facto corporation and corporation by estoppel doctrines if there was a good faith effort to create an LLC. Operating agreement. Organizational articles only reflect LLC's existence, but LLC may also adopt operating agreement to govern business. Agreement can be oral, in record, or implied by conduct. Statutory default provisions apply when operation agreement is silent. Default management arrangement is member-manager. Membership. No limit, but some states require at least 2 members. To become new member requires all other LLC members' consent. Membership interest transfer also requires all members' consent. Membership transfer. Transferee only acquires transferor's right to share in LLC's profits and losses, not a right to participate in LLC's management. Membership termination does not automatically trigger LLC's dissolution. LLC may elect to liquidate fair value of that person's interest. Profits and losses allocation. Unless determined by operating agreement, allocations are made according to each member's contributions to the LLC. Inspection rights. LLC members generally have inspection rights similar to corporation shareholders. Management. Can be direct by members or centralized by one or more managers who need not be members. Involves liabilities, duties, authority to bind, and disassociation. Liabilities. Members generally are not liable for LLC's obligations. Managers are not personally liable for obligations incurred on LLC's behalf. Piercing veil. Members may be liable if veil is pierced due to undercapitalization, assets commingling, business affairs confusion, or creditors' deception. Mere instrumentality test. 1. Members dominated entities such that LLC had no will of its own. 2. Members used that domination to commit fraud or wrong. And 3. Control and wrongful action proximately caused the injury. Unity of interest and ownership test. LLC did not have existence independent of members because such unity of interest and ownership existed between entity and members that failure to pierce veil would be unjust or inequitable. Creditors can obtain charging order, judgment lien against members' LLC interests, requiring LLC to pay judgment debtor distributions that otherwise would be paid member. Operating agreement cannot alter this rule to prejudice of third parties. Duties. Members owe each other and managers loyalty and care duties. Must account to LLC for any member-derived benefit related to LLC's business. Refrain from dealing with LLC on behalf of one having adverse interest, and refrain from competing with the LLC. Care duty to LLC is business judgment rule subject. Members are not liable for simple negligence. Fiduciary waivers are recognized in LLCs, may agree to specific activities that do not violate loyalty duty, as long as agreement is not manifestly unreasonable. Authority to bind. Manager has authority to bind LLC. Dissociation. Member can withdraw any time for any reason without written notice. Withdrawal does not necessarily trigger dissolution and winding up. Dissolution. LLC may merge with another LLC or other business entity. May dissolve on occurrence of various events. Members' mutual consent, lack of members for 90 consecutive days, court order or events provided in operating agreement. Members may seek involuntary dissolution if controlling member acts in a way that is oppressive and directly harmful to member seeking whatever that is. Order. Action must violate members' reasonable expectations. Winding up. LLC must discharge LLC's debts, obligations, or other liabilities and settle and close LLC's activities and marshal and distribute LLC's assets. May perform acts necessary or appropriate to winding up. Direct and derivative suits. Direct. Action to enforce members' rights as member under operating agreement and state LLC statute. There must be actual or threatened injury that is not result of LLC injury. Derivative. Action by member on LLC's behalf to enforce LLC's rights. Must show demand was made or demand would be futile. And we're done.